Case on this morning's docket. That is case number 111127 in the matter of Michael Pelequin.
May it please the court, the Office of the Disciplinary Administrator appears by Kimberly Knoll, Deputy Disciplinary Administrator. Mr. Chief Justice, I'd ask for 3 minutes for rebuttal, please.
3 minutes is granted.
Thank you. As the court is aware, this matter is before you on an original disciplinary action. A hearing panel found that the respondent, Michael Pelequin, violated Kansas Rule of Professional Conduct 1.3, diligence, 1.15, safekeeping of client property, and 5.3, failing to supervise non-lawyer assistance properly. The hearing panel recommended that he be suspended for a period of 3 months. Mr. Pelequin has requested probation. In the hearing panel report, the panel recommended that immediately and before oral argument that the respondent undergo a complete psychological evaluation to determine if he suffers from a mental condition that impairs his ability to represent clients. To date, I have not received any evaluation. The panel also recommended that he attempt to determine any other checks that might have been negotiated by the office manager without authorization. To date, there has not been any discussion or any information provided on any efforts being made to do that. The probation supervisor, Ms. Williams, has sent a probation acceptance and account of first review. That was received the day before the hearing. And the panel found as a result that he had met with her the day before the hearing that the plan was not actually in place and in effect at the time of the hearing, which was another reason that the panel rejected the request for probation. Since that report, Ms. Williams has provided 3 additional reports, one on December 31st, 2013, one on April 1st, 2014, and one on July 1st, 2014. The July report indicated that he had attended some CLE, which was also a recommendation in the final hearing report, but there were no CLE affidavits attached to show that there was actual compliance with that. There have been no proof of any payments other than a statement in one of Ms. Williams' reports saying that they had discussed that he was attempting to keep current with all of his payments, restitution, especially for EG and the Wesley Medical Center case. As this court is aware, Supreme Court Rule 211G5 requires that prior to argument that a respondent file an affidavit with the court that shows compliance with the probation and everything is going well. As I've mentioned, the recommendations of the panel for the most part have not been followed, and additionally, as of right now, there has not been an affidavit filed with the court. As far as disposition goes, we oppose the probation plan because he is not in compliance, and the hearing panel correctly found that he wasn't even in compliance at that time. We normally do not change the recommendations from the hearing to now. However, because of the lack of any effort made to provide compliance, to get the evaluation, I am changing my recommendation and I'm going to ask this court to consider an indefinite suspension. These were significant issues, and at the time, it was my belief that if Mr. Pelequin did engage and did address the issues that the panel identified, that the public would be protected. I have lost that confidence because of the lack of any kind of information or any kind of proof.
When was the hearing panel report
submitted?
When was the finding made that he should provide this information?
The date of the hearing report?
Yeah.
It was the 21st day of January 2014. And the hearing itself was held on October 17th of 2013.
Thank you.
So
Why do you ask us to go all the way up to indefinite suspension? Because the panel recommended a reinstatement hearing after the 3 months, and doesn't the reinstatement hearing provide us the public safeguard?
It does.
To look at all that rather than wait 3 years to to do something?
And I believe that there was an exchange yesterday with Mr. Walzak on the same issue. It's our office's position that when you're dealing with psychological issues, that, well, first of all, we don't think it's fair that a person after 6 months or a year pays the $1,250 thinking that they are good to go when they're not and they get denied. That seems kind of cruel to us. Secondly, when you're dealing with deep-seated psychological issues, which I believe the panel identified in this particular case, it's more than a year. And at this point, because we don't have any information that he has done, I know he's seen a physician, but I'm not sure where he's at with his mental health, it would be one thing if he had already been in treatment and came here and said, I've made the X progress. But I just don't.
But yesterday, we had a finding from the panel that that the respondent in that case, not this case, in that case, was unfit to practice law.
Correct.
That finding's not in this, as I recall.
Well, on page 11,
Yeah.
it talks about the purpose of the evaluation, which I read, and then it talks about if there is a reinstatement hearing, the respondent be required to establish that his health and memory are sufficient to engage in the active and continuous practice of law. And so I read that as that there is some question about fitness, even though they don't specifically come out and say there's an actual finding. That last part that I read is at the top of page 12 of the final hearing report.
We have any further questions while he's looking at your citation? Justice Biles, any further inquiry?
No, I guess I'm a little puzzled by your response. I don't know that it really requires anything more. The hearing panel members are, experienced at this process. And so I think I would read into it the other way, that since they didn't make a specific finding of the respondent being unfit to practice law, but sort of made this recommendation, I'm not saying that the respondent shouldn't follow up on a recommendation before showing up here, but it doesn't seem to have the same punch as a finding of unfit to practice and then a more substantial suspension than the 3 months. So I don't imply the way you do.
Okay,
With this.
and that's fair.
Any other questions? Thank you,
Thank you.
counsel.
May it please the court, justices. I'm not sure really where to begin. So if you have
Well,
questions,
yeah,
throw
Why
them
why
out.
don't you start with why didn't you follow up with what the hearing panel said you were supposed to do?
I did.
Tell us what you did then.
Okay. Well, I was contacted by KLAP, and they recommended that I undergo a contract with them, which I did. I've been reporting to KLAP once a week since I entered into that contract.
And when did you do that?
I think I started that about 5 months ago.
Okay.
And I was, in reading the opinions, I was under the impression we couldn't bring in new evidence. I had discussed what I was doing with my probation officer and with KLAP, but I guess I didn't realize we could talk about new evidence. It was a recommendation by the panel. I'm not sure why they recommended the mental evaluation. I think they thought I was stressed out, and I am because of this. And that's why I got that call. I did not have a lot of trust for KLAP in the beginning. And the reason I didn't have trust, it stems from, if you look at the transcript, and I do now. I've talked to my KLAP representative and then the head of KLAP a number of times. But in the beginning, when I went for my disciplinary hearing, there was an investigation done by an investigator in Wichita. And you can read this in the transcript. And that he had done a thorough investigation, and I informed the board that this had been done. And, I was curious about the finding, because when he talked to me on the phone, he said, I was going to recommend something like diversion. And we had a colloquy with the board about that, and I was told that that investigative report, which did have a finding of negligence, which does support the arguments in my brief, was going to be shared with the board. And then it wasn't made a part of the record, and I just got real distrustful after that. But I do see a psychiatrist. I am for what he says, stress-related depression. And I found one literally right next door to my office. So
How often do you see your psychiatrist?
often, usually once a week, sometimes once every 2 weeks. Since you asked, since that time, I've been searching for a doctor. My stuff really isn't a mental thing, it's a physical issue. Like identified at the hearing with, it started out as autoimmune and then had thyroid, had one doctor that wanted to take a thyroid out, one who said that would be medical malpractice. I was throwing up blood in Judge Wilbur Court, just all sorts of health problems. And so no matter what happens today, I'm very nervous in front of you, but I'm very grateful. I have finally, many doctors later, found a doctor that has started to solve this. Dr. Farney in Wichita, Kansas, started out from a business discussion with another doctor who recommended I go see him. Miss Knoll recognized that I'm almost 30 pounds lighter than when I appeared at the disciplinary hearing. Dr. Farney's belief, and he focuses on internal medicine, and is an internist, is that all my problems, they started thinking autoimmune and then they switched a number of times, but really are autoimmune. And his position was the best way to deal with autoimmune is first to fix your insides. Because from what I understand, the particles of what you eat, if you have autoimmune condition, they get into your blood and your nutrition, and your body starts attacking with its immune system. Starts attacking the very stuff that's supposed to make you nutritious. Had a test done, cost me, I think about $800. Because it was something my insurance didn't want to pay for. And come to find out, and I wish I would have known this 5 years ago, I wouldn't be here today, that probably 80% of what I was eating was hurting me. At the time of the hearing, we identified that I had celiac. Well, it turns out I can't even have any dairy products, any black pepper, any melons, anything with sugar, because it increases yeast production, and I'm allergic to both brewer's and baker's yeast. Almost 30 different things, which I've shared with my probation officer. It's a very hard diet. KLAP had me create a log of my activities, of what I eat, and so did my doctor. And I'm not all the way. It's going to take some time, but it's dramatically affected me. I've been able to, I actually walked 10 miles in one day. I hadn't done that for years.
Well, given all of that, are you, as you've appeared today, are you physically able to practice law?
I am. I have bad days still. And I think I've been thinking a lot about the proposed probation plan, and some modifications that you got to understand. I never wanted to put any clients in this position. I very much care about my clients, and that's something me and Ann McDonald had talked about. Learning also to put myself at distance from my client and be able to be professional, because I do represent some people who are in what Ann called very unique circumstances, and I can't take those on, and when I'm dealing with health issues, maybe that's where the mental comes in because of stress-related depression. But I think like additional things that should be in any probation plan, or if you do suspend me with reinstatement, is, you know, the continued counseling. I think that's good. It has proved very good for stress management techniques and things like that. Also, maybe a compliance with the diet that was recommended by Dr. Farney, because that's the one thing that has drastically changed my life. And that should, you know, be monitored. I already logged my stuff, but continued logging of that. And then I know Dr. Farney said after a period of time he'd like to retest me and look at those results because my diet, it may change. So a retesting procedure that I comply with that should be added to that.
Before you sit down, what are you asking us to do?
I would like, I have been paying restitution. I would like the opportunity to do that. It's easiest if I'm practicing law. If I'm not practicing law and I'm suspended, I've been trying to take some steps, other career steps. I found out that I was good in programming in college. Found out I'm still good at it. And I think I've started trying to develop some apps for attorneys to use that I always thought should be out there but weren't there. So I'm trying to take some steps in that direction so I can still pay restitution if I'm suspended. But I would like you to consider reprimanding me, allowing me to practice law, continuing on the probation. I know the disciplinary board recommended 2 years, and I didn't put a time frame on mine when I submitted it to the board. I think, frankly, I need to be on probation until I have a psychiatrist, maybe, if you really are concerned about the mental health, and a doctor saying I'm fully fit to practice law full time. I think that's fair.
The other action the hearing panel wanted you to take, and Ms. Knoll mentioned it, was some sort of accounting of the other potential losses that occurred as a result of your office manager. Have you undertaken that task?
I've been doing that task for a long time. What I tried to make clear to the board, when this occurred, my mainframe was taken, as were all these files. And so it's very, the Overland Park Police Department notice. I kept 2 sets of files in Wichita and Overland Park. He took the files that were embezzled. I think we have it all. I think we got everybody, but there is no way I can ever be certain for you because he took my records. But yes, I have worked on that. I've gotten some list of active cases that I was personally entered on in district court and was able to go to clerk and get that. But I maintain a public presence on the internet. I don't have a website, but I maintain my Facebook site. And I mean, that's what I got. So, any other questions?
Do you have any other input for us on what you would like for us to do about your situation? Because this is your chance to tell us you're not going to have another one.
I know. I think I was better. Sometimes I'm a better writer than I am a speaker. I think I outlined my position in my brief pretty well, and I would ask that you take a close look at that. Thank you.
Do we have any more questions of council? Thank you. We reserve 3 minutes for rebuttal.
I just want the court to be aware that KLAP cannot communicate with us. This is the first that I had heard that he was working with KLAP unless there is a release signed. And I'm kind of confused about the comment that somehow he didn't trust KLAP because an investigative report wasn't made part of the record. KLAP has nothing to do with the disciplinary aspect. They are there to support and to assist, and if there is a release, to communicate with us the steps that are being taken, and that did not occur in this case. Additionally, investigative reports do not become part of the record because they contain hearsay and all kinds of other things. That's why we call the investigator to provide live testimony. I just wanted to make those two comments.
Any questions? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement.